Where's the music? Where's the intro for our friend Kendall Coffey? You see, in previous weeks we played it, and while we got Kendall on the phone, but now Kendall's on the phone. So hey band, can we get the band in here? Do we have the band? Give me a thumbs up. All right, here comes the band, because we cannot start this segment without the appropriate introduction for our friend Kendall Coffey. Hit it.
You have the right to remain silent, but we'd prefer if you didn't.
Spinning the law, spinning the law.
This is Malzberg's
Spinning the law,
Spinning the Law,
spinning the law, spinning the law.
with attorney Kendall Coffey.
There you go. Now we got it right. Now we can start the segment. You believe it? Kendall, welcome back, sir.
Thank you so much for making my day with your amazing musical intro.
Do you believe it's Thursday again? I mean, really, we just spoke.
It was 2 days ago.
We
wasn't
just
it?
spoke, but I'm really glad that you make the time for us, and you know, almost all the time, and it's a wonderful treat. Lots to get to, and of course, Kendall, famed attorney and author of the great book Spinning the Law. When are you going to do a Spinning the Law Volume 2? Because certainly you got many volumes in you.
Oh yeah, and there's been so much that keeps coming out. But hey, in all my spare time and all your spare time, we'll figure something out.
Okay. Oh, I'm in on this. Good. I like that. Okay. Now let's start. The Supreme Court hearing a case involving prayer said at the start of a town council meeting in Greece. Not Greece, the country, but up at Greece, New York, outside of Rochester. It's the court's first legislative prayer case since 1983, when the justices said that an opening prayer is part of the nation's fabric and not a violation of the First Amendment. Now, the federal appeals court in this case in New York said that the town violated the Constitution by opening nearly every meeting over an 11-year period with prayers that stressed Christianity. So where do you think we're headed here?
Well, and of course, the Supreme Court session began with the traditional words that included "God save the United States" and this honorable court. And whatever your religious background, if you like money, you'll see the words "In God We Trust." So it's recognized fundamentally that it is part of the fabric, it's part of the tradition. Can a prayer or can some sort of officiating practice go too far? That's what the case is about. But I think the case is about a lot more than that potentially, Steve, because the whole question of church and state and the dividing line has been a difficult one for the Supreme Court. And it'll be interesting to see if this case is simply a prayer in a government meeting case, or if it get a little broader than that. You remember the cases and the controversies about religious displays during the holiday season. It goes potentially that the element you see in this case could have implications in terms of whether the extent to which public funding can be used for religious schools. All of these issues have been sort of waiting for a catalyst from the Supreme Court since Sandra Day O'Connor left the court, because she was a key vote who advocated very strict neutrality in church and state issues. Others take the position that, look, as long as a prayer doesn't become a tool of advocacy for one religion or another, if it's simply a recognition that this is a solemn occasion, this is a public occasion, we all recognize that even if we're public officials, that we are not the highest authority in the land. That sense is I think, consistently recognized as legitimate. If a prayer takes the form of specifically advocating for one religion or disparaging another, then it's in a different zone. This particular practice, I think, is going to be a very close call. I would not be surprised if the Supreme Court validates and supports the town council in allowing this kind of public prayer because of the decision 30 years ago, because recognizing that there's a higher power than any of us is part of our tradition, whether it's on our dollar bills or whether it's when the Supreme Court is seated. But again, keep an eye out, Steve, not only for the result on this. I suspect the town will win, but whether the opinion is written in such a way that signals further develop in what could be an emerging conflict or emerging controversy, and perhaps some new law on this whole subject, emotional and very, very profoundly important, of church and state.
Yeah, and of course, interesting to note that Greece, the town of Greece, is being backed by not only social and religious groups, conservative groups, but also the Obama administration is on the side of the Greece here.
That's striking, and I think it's part of the reason why I think that the town council will win. It's simply not an aggressive or very offensive practice. But again, let's see if it's a narrow decision, or let's see if it's opening the door to a broader reexamination.
All right. There's another case here, and this one seems a little bizarre, but a California police officer won his appeal Monday at the Supreme Court after he was sued for chasing a suspect onto private property without a warrant. And the issue, I guess, is whether a homeowner's expectation of privacy was violated, since there was no immediate danger, they say, to law enforcement, and the alleged offense, disobeying the police, was a misdemeanor. So, to me, I don't see how you make that distinction. If you're chasing somebody, you're not going to, as a cop, you're not going to stop just because that person, if there's a legitimate reason to chase them, you're not going to stop because that person then runs onto private property.
Yeah, and there's a very strong recognition of the needs of police officers to be able to continue a pursuit. In this case, the officer apparently acted in good faith. There had been issues about violence in the area. There was a disturbance where it was alleged that somebody was threatening others with a baseball bat. Police officer was doing his job, acting in good faith, and the court held, and I don't think this will be considered a controversial decision at all, held specifically that the police officer could not be sued for acting in good faith and attempting to pursue someone that was believed to have been involved in a crime. It's of comfort, I'm sure, to police officers, because if the court had gone the other way, can you imagine the dilemma for our law enforcement?
Yeah, crazy. I mean, they don't have enough problems. Then they got to determine if where they're chasing someone is actually public or private property. Plus, it would give safe haven to criminals. They're not all of them are that stupid. Some of them would know what they're doing. We're talking to Kendall Coffey here on the Steve Malzberg Show. We're spinning the law, as we like to do every Thursday at this time. Okay, another Supreme Court here. Steel workers, and this is kind of bizarre too, who do their jobs wearing flame retardant gear, are have argued before the court that they should be paid for the time that they spend putting on and taking off their clothing and affiliated items before and after their shifts. And this could affect unionized workers in poultry processing, meat packing, and other sectors. To me, I don't know. I'm not a big union guy, but it seems to make sense, especially leaving work, that you're going to want to take those clothes off and change into something. So maybe they should get 5 minutes. I mean, I can't believe we're arguing over 5 minutes here, which is basically all it could take, right?
Well, it depends on the what you call the clothes, or whether you call it gear, whether it's garb or gear, and how long it takes. Certainly from an employer standpoint, 5 minutes here, 10 minutes there, every day, every worker, it starts to add up. It starts to add up. But I think the frustration the court had is that, look, you've got a category of different things, from fire retardant jackets, fire retardant pants, steel-toed boots. You kind of put them on like clothes, but some of that stuff takes a while and some special procedures to put on, and it isn't the same clothes that you and I wear. Although I've seen you in steel boots, and I kind of like it, but
I am not going anywhere near that. Not with
no. But our both sides have a kind of legitimate viewpoint. I think that to the extent that they're putting on things that take a significant amount of extra time, and that really have fundamentally a safety feature that's specific to the hazards of their job, sounds like a pretty good argument to me.
Yeah, no, I agree with you. All right, now one more here. Skakel, Kennedy cousin, as he's known, Michael Skakel, a new trial. We talked about this. The judge has ordered a new trial, and the attorney for Skakel, Michael Skakel, has tried to get him released on bail pending that new trial, but it's been denied. Are you surprised?
Well, I think what what the trial judge is trying to do is get some more information about where the next appeal is going, because the prosecution lost the appeal, but they're pursuing this. They're not going away, and their view is that, look, if you in effect start all over again, let him out of jail on bail, go to a new trial, and you could imagine the ordeal that would be, for among others, the family, the victims, and the system. And putting the case together years ago was tough enough. Putting it together, a year from now is mind-boggling. Prosecution is saying, look, let us find out if this appellate decision that granted a new trial is really going to hold up. We think that appellate decision granting a new trial was wrong. We want to challenge it. And until we sort that out with the next level of judicial review, let's not turn back the clock and try to start this whole thing again. Let them out, start the trial, try to put the pieces back together. Hold everything, and let's see what is finally going to be the decision about whether Michael Skakel gets a new trial.
Yeah, very, very interesting. All right. Well, Kendall, we had a lot of interesting cases today, and I'll start my search for next week as soon as we hang up.
Okay. Great talking to you,
Thank you, Kendall. You too.
See you next time.
Kendall Coffey, ladies and gentlemen, as we go spinning the law with Kendall every Thursday at this time. Very interesting. I don't know how on earth they could have a new trial for Skakel, as Kendall and I discussed, I think, a week ago. So many of the witnesses are no longer with us, or their memories are shot, or it's just going to be very, very hard to pursue a new trial. And I'm very anxious to see if the prosecution does attempt to go there, or what's going to be worked out. But Robert Kennedy Jr. has been all over TV from the day that this decision was reached, saying that my cousin was railroaded, and there were 5-10 witnesses who said he didn't do it, and he had an airtight alibi, and but not everything that RFK Jr. is saying, in my opinion, is all that accurate. Otherwise, he was convicted by a jury of his peers. They heard all the evidence. They claim that the attorney for Skakel did not adequately represent him, did not give some of the evidence in that Skakel might have wanted to have admitted, such as some of the witness testimony, but who could have corroborated an alibi. But that's that story. All right, when we come back, I want to talk about Yasser Arafat. Yasser Arafat, he was a great man. You should have heard CNN. To me, one of the most insane things I ever heard was Larry King interviewing Yasser Arafat, and it's like asking Hitler, because Yasser Arafat's the second biggest killer of Jews next to Hitler, in my opinion. And Yasser Arafat sat there, and Larry King says, "Hey, Yasser, tell us about the hat. What's with the hat?" It's like asking Hitler, "Hey, Hitler, hey, Adolf, what's with the mustache? Tell us about the mustache." Insane. But that's what Larry King asked him. I used to play that soundbite all the time when I was at WABC. All right, we're coming back. A little more about the poisoning of Arafat and Hitler, by the way. Steve Malzberg's show.